Welcome to Season 2 of the More You Know Media and Tech Literacy series, produced by Independent Thinker, LLC. The More You Know Media and Tech Literacy series is a quarterly educational initiative that helps individuals and communities better understand the realities of today's digital ecosystem. In Episode 2, we cover the digital front lines of abortion access in an AI era. We turn the mic to Tommy and Gina for an insightful discussion about this topic.
So, if you just glance at the headlines on any given day, you would probably assume the whole battle over reproductive rights is happening entirely in, sterile waiting rooms or at the doors of physical clinics.
Right, or like on the floors of state capitol.
Exactly. But if you actually look at the data and the current legal landscape, the front line isn't really physical anymore.
No, not at all. It's a massive paradigm shift.
Yeah, that private doctor's visit has basically spilled out into the federal postal system, into the hidden algorithms of your social media feed, and deep into the data servers that track your daily movements.
We are no longer just talking about geographic borders or the walls of a medical building here. I mean, the battleground is literally the smartphone in your pocket. It's the digital footprint you leave behind, and really the fundamental architecture of the internet itself.
Which is wild.
Yeah.
And that's why we have a truly fascinating mission today. We are doing a deep dive, synthesizing a massive stack of recent sources. We've got stuff spanning from the ACLU and the Electronic Frontier Foundation to expert panels and interviews on Democracy Now!, as well as the EFF's YouTube channel.
Yeah, there's a lot to get through.
Right. And our goal is to explore how the fight over abortion access in the United States has rapidly evolved from physical borders into, quite frankly, one of the most complex digital privacy and legal defense battles of our modern era.
And because this evolution touches on these deep systemic changes across multiple states, federal agencies, and, private tech companies, we are going to be looking at a lot of colliding, highly charged viewpoints.
Definitely. Which means, before we jump into the deep end, I need to set some ground rules for our discussion today.
Yeah, that's important.
Because our sources contain politically charged viewpoints from both sides of the abortion debate, ranging from reproductive rights advocates like the ACLU to pro-life advocates like Susan B. Anthony Pro-Life America, this deep dive will impartially report the factual content provided. So, to be totally clear, we are not endorsing any of the viewpoints found in these sources. Our goal is simply to convey the ideas, arguments, and developments exactly as they appear in the original material so you can understand the full picture.
Right. We are just mapping the terrain exactly as it currently exists. And I mean, the terrain right now is moving at an incredibly chaotic pace.
Okay, let's unpack this. Because the immediate legal fallout of the Roe v. Wade reversal has created a situation that is changing so fast, it feels like even the lawyers can't keep up.
Oh, absolutely. They're scrambling.
Yeah, we're seeing this unprecedented response. Specifically, the sources highlight what the ACLU has done by launching the Abortion Criminal Defense Initiative, or the ACDI. This is directed by Lauren Johnson, alongside attorneys like Liz Jarrett and Emily Follansbee.
Right, and they have rapidly built a network of over 150 criminal defense attorneys operating specifically in states where abortion is banned.
It almost feels like they had to build a legal fire department overnight because the specific laws and precedents are burning down and being rewritten in real time, which is creating massive confusion even for local law enforcement.
Yeah, and the necessity of a network that size speaks to a pretty terrifying reality in the legal world.
How so?
Well, there's a huge gap between what a statute actually says and how local authorities choose to wield their power. When a major precedent falls, it creates this vacuum. And in that vacuum, local prosecutors are testing boundaries in ways that sometimes completely ignore the written law.
Yeah, the sources gave a genuinely stark example of this. Take the case of Gonzalez v. Ramirez in Starr County, Texas.
Oh, right. That one is really telling.
It is, because Texas law explicitly prohibits prosecuting patients for terminated pregnancies. It is written down in black and white as a clear legal exemption for the patient.
Right. The law says you can't prosecute the patient.
Exactly. But despite that, Starr County officials indicted, arrested, and jailed Lizelle Gonzalez for having an abortion.
And when local officials just ignore a clear statutory exemption to put someone in jail, the chilling effect is profound. I mean, it sends a message to the public that the letter of the law will not protect you from the power of the state.
Yeah, even if the charges are eventually dropped, right?
Exactly. The damage is already done. The fear is established. And that is the exact environment that necessitates a preemptive, 150 attorney defense network.
And prosecutors are getting incredibly creative with how they pursue these cases, too. There's another case highlighted in the material, Moira Akers v. State.
Yes, the intent argument.
Right. Prosecutors there literally tried to use a person's right to decide whether to terminate a pregnancy as proof of intent for murder. They attempted to twist the exercise of a fundamental right into the foundational evidence of a criminal act.
It's a huge legal leap.
It really is. Furthermore, the ACLU notes the risk of facing this kind of aggressive, boundary-pushing investigation is not distributed evenly. Black, brown, and low-income individuals are disproportionately the most likely to be investigated.
And this aggressive testing of boundaries isn't confined to local county prosecutors either. It scales all the way up to the federal level, especially when you look at highly vulnerable populations who don't have the resources to fight back.
Yeah, the sources detail a major Freedom of Information Act, or FOIA, lawsuit filed by the ACLU and the National Center for Youth Law. They are demanding transparency from the Trump administration regarding pregnant, unaccompanied immigrant youth held in federal custody.
Trying to find out if they're being denied care, right?
Exactly. They're pointing to a previous 2017 policy that actively blocked these marginalized young people from receiving abortion care. So the front line of this battle stretches from a county jail in Texas all the way to federal immigration holding facilities.
And when you look at the sheer legal peril surrounding physical clinics or even local hospitals, it becomes pretty obvious why the entire landscape of medical access had to pivot.
Right, because physical spaces are effectively shuttered.
Or heavily monitored by aggressive prosecutors in ban states, so the method of delivery has to fundamentally change.
But wait, if the physical clinics are closed and going to a local hospital carries the risk of a criminal investigation, how are millions of people actually getting care?
They're using the mail.
Just the regular mail.
Yep. The primary method of access has bypassed the clinic entirely and shifted to telemedicine and the federal postal system.
Which brings us to a massive legal collision over the abortion pill, specifically mifepristone. The sources state that this medication is used in nearly 2/3 of all U.S. abortions, and over 1 in 4 people use telemedicine to get it.
So this isn't some niche alternative. It is the overwhelming standard of care right now.
Right, and because it is the standard of care, it's the primary target of litigation.
The major flashpoint here is the Louisiana v. FDA case. The conservative Fifth Circuit Court of Appeals ordered a nationwide restriction on mifepristone. They attempted to reinstate an older rule that requires in-person pickup, which would effectively block telemedicine distribution entirely.
Oh, wow. So you'd have to go physically get it. But didn't the Supreme Court just step in?
Yes. Just recently, on May 4, 2026, the Supreme Court issued a one-week pause on that restriction while litigation proceeds.
Okay, let's look at the viewpoints driving this litigation, because the sources lay out an incredibly stark contrast here. On one side, you have Katie Glenn Daniel from Susan B. Anthony Pro-Life America. She argues unequivocally that these pills are deadly for unborn children and extremely dangerous for mothers.
Right.
She states they must be taken out of the mail immediately so that predators and abusers cannot access them. You also have Senator Josh Hawley echoing this sentiment, warning that allowing pills by mail is turning every mailbox in America into a Planned Parenthood.
And those arguments form the absolute foundation for the push to enforce physical in-person restrictions and uphold these state-level bans. But the medical data presented by the opposing side paints a totally different picture.
Yeah, on the other side, you have journalists like Amy Littlefield from The Nation, alongside the ACLU, pointing to FDA data and over 100 independent studies. They argue the data proves mifepristone is incredibly safe.
What were the exact numbers they cited?
They cited that out of 6 million uses over more than 20 years, there have been only 32 associated deaths.
Wow. And the tension between those two viewpoints is really what is fracturing the legal system. But the data reveals something highly counterintuitive about the actual real-world impact of these physical state bans.
Yeah, I need you to pause for a second because the math here is breaking my brain a little bit.
I know, it's surprising.
According to the sources, abortions have actually increased since Roe fell. If abortions are actually going up despite these sweeping physical bans, doesn't that suggest the state bans are completely failing at their stated goal and simply moving the entire conflict into the federal postal system?
It seems contradictory, right? Until you look at the mechanisms being used to bypass those state borders, we are witnessing a jurisdictional collision.
How so?
Well, state bans are essentially hitting a brick wall when they encounter the federal mail system, international pharmacies, and out-of-state shield laws.
Let's dive into the mechanics of those shield laws, because it is a fascinating legal workaround. Clinicians in states like New York and Massachusetts are protected by their own state's shield laws. How does that actually work in practice?
Think of a shield law as a localized firewall against out-of-state investigations. A state like New York passes a law instructing its own law enforcement, its courts, and its medical boards to refuse cooperation with any out-of-state investigation regarding legally protected healthcare.
So if a prosecutor in Texas issues a subpoena or an extradition request for a doctor in New York who mailed a pill to a Texas resident,
New York simply ignores it.
that is wild. So these doctors are utilizing telemedicine to prescribe and mail pills directly into states where abortion is banned and their home state is shielding them from the legal blowback.
Exactly. And on top of that, activists are shifting to what they call Plan C.
Right, the sources mentioned that. It's a World Health Organization recommended protocol that uses only misoprostol, which is a different drug that isn't currently blocked by the court orders targeting mifepristone.
Yeah, and it just demonstrates the logistical nightmare of trying to stop a decentralizable medication via geographic borders. You cannot put a checkpoint on every single piece of federal mail.
No, you really can't.
However, the chaos of this fragmented system carries a severe human cost.
Yeah, the sources highlighted research from Johns Hopkins finding a 9% rise in pregnancy-related deaths in states with abortion bans. That is 68 additional deaths by the end of 2023.
And those tragedies often occur in cases involving complex miscarriages or severe pregnancy complications. When doctors are terrified of violating vague state bans, care is delayed. The legal confusion itself becomes a barrier to emergency medical intervention.
But think about the logistics of this workaround for a second. If you live in a state with a ban and you need to utilize a shield law in Massachusetts or figure out how to safely use Plan C, how do you even know who to call?
You have to search for it online.
Exactly. Therefore, the battleground naturally shifts from the physical mail system to online censorship.
Right, because information is the necessary precursor to medical access. If authorities cannot physically intercept the mail, the next tactical maneuver is to stop the flow of information explaining how to obtain and use the medication.
Here's where it gets really interesting. Because we aren't just talking about government censorship anymore. We are talking about algorithmic moderation by massive private tech companies.
Yeah, the EFF, the Electronic Frontier Foundation, launched a hashtag Stop Censoring Abortion campaign in 2025.
And what they revealed is that Meta and other social media platforms are actively suppressing, shadow banning, and outright removing educational abortion content.
And the underlying issue is how these automated systems actually function. Because the EFF found that almost none of the censored posts were actually violating the platform's stated policies.
Right, the platforms are citing their restricted goods and services policies. And those rules exist for a good reason, They're meant to ban the illegal selling of pharmaceutical drugs online.
Sure.
But the algorithms aren't sophisticated enough to understand context. They are flagging and removing purely factual educational content about reproductive health. It's like a digital game of whack-a-mole played with a blindfold.
That's a great way to put it.
The AI scrapers see the word mifepristone, assume it's an illegal drug sale, and use a sledgehammer on the post, entirely missing the nuance of free speech and education.
And this automated failure forces health educators into an impossible position. The EFF noted that to get wrongfully removed accounts restored, organizations often have to rely on internal back-channel connections at Meta.
Oh, wow. So if you don't know someone.
Exactly. If you are a grassroots activist without a personal contact inside the company, your educational content just disappears into the void without any recourse.
But lawmakers aren't just letting the tech companies police themselves, are they? They're actively trying to codify this censorship into law.
Yes, the sources pointed to Texas Senate Bill 2880.
Right. This bill, which ultimately failed, attempted to make it a crime to simply provide information online about abortion drugs. And the scope was massive. It didn't just target the individual posting the information. It targeted the social media platforms, the email services, and the messaging apps hosting the conversation.
The tension here is immense. Private platforms like Meta have First Amendment rights to curate the content on their sites, yet their flawed moderation tools are acting as a de facto gag order on reproductive health education. When you combine that corporate suppression with aggressive state-level legislative attempts to criminalize sharing information, you are looking at a highly coordinated squeeze on the mere discussion of medical access.
And it gets even more insidious. Louisiana and several other states are pushing age verification laws.
The digital ID laws, right?
Yeah, these are usually framed as child safety bills, requiring users to submit government IDs to access adult content online. But the EFF warns that the architecture of these laws is incredibly dangerous.
Because of the precedent it sets.
Exactly. Once the infrastructure exists to demand a government ID to access specific websites, it could easily be expanded. They could require users to submit IDs just to access reproductive health information, completely destroying any semblance of online anonymity.
And this is the critical pivot point in the conflict. We have moved from policing the information you are allowed to see online to the final and arguably most invasive battleground.
Which is
The information you are actively creating without even knowing it. It is about what your devices are silently broadcasting about you.
the surveillance web. Yeah, we have an incredible panel transcript from EF.org featuring digital rights experts Cynthia Conte-Cook, Daley Barnett, Haley Sukayama, and Audrey Perez. And they completely dismantle a piece of advice that went incredibly viral after Roe was overturned.
Oh, the app thing.
Yeah. Remember everyone saying, delete your period app?
It was like the most common piece of digital security advice circulating at the time. Everyone was sharing it.
But the panel experts point out that this is an overly simplistic, flattened solution that fundamentally misunderstands modern threat models.
Right. Deleting one app does nothing if the device itself is a walking tracking beacon.
Yeah, the experts pointed to a specific terrifying case in Nebraska. The police didn't need a period tracking app. They successfully subpoenaed Facebook for a mother and daughter's private direct messages to prosecute an abortion case.
Just their regular DMs.
Those regular DMs.
Yeah.
Prosecutors use that everyday communication data to prove the legal element of intent.
And intent is notoriously difficult to prove in criminal cases. But our daily digital communications, our text messages, our search histories, our DMs, they provide a meticulously time-stamped map of our thoughts, fears, and intentions.
It's terrifying. And the surveillance isn't just in our pockets. It is physically built into the streets. The panel highlighted the danger of ALPR's automated license plate readers.
Right, the cameras.
Yeah, these cameras are constantly logging vehicle movements across state lines, sharing that data across jurisdictions. But the emerging threat that really stopped me in my tracks is the rollout of digital driver's licenses.
Yes, this is a crucial, rapidly accelerating development. Over 30 states are currently rolling out digital IDs, frequently without any meaningful legislative debate or restrictions on how the underlying data is stored and shared.
Think about your digital wallet right now. Are we blindly trading our fundamental right to anonymous travel just for the convenience of not carrying a physical driver's license?
It's a huge trade-off.
Because when a bouncer checks a plastic ID, the interaction ends there. But when you use a digital ID at a hotel, renting a car, or boarding a train, it requires a cryptographic handshake with a server. It creates a verified, time-stamped digital breadcrumb of exactly where you are and when you were there.
And if states are actively trying to criminalize traveling across state lines for care, that digital ID becomes the ultimate unavoidable tracking mechanism.
Which forces us to ask how individuals can possibly protect themselves against an architecture of surveillance that comprehensive.
And the panel's conclusion is sobering. You really cannot individualize a systemic problem.
Yeah. Daley Barnett from the EFF mentioned some grassroots individual solutions. Things like compartmentalizing your data, using different web browsers and email addresses for sensitive searches, using encrypted networks like Tor, and relying on resources like the Surveillance Self-Defense Guide or the Digital Defense Fund.
All good practices, sure.
But the overarching consensus of the panel is that personal tech hygiene is not a substitute for systemic reform.
Right, because if an unregulated data broker is legally permitted to sell your raw geolocation data, or a network of automated license plate readers logs your vehicle crossing a state line, all the encrypted browsing in the world won't shield you from investigation. The threat is infrastructural.
That is why we are seeing legislative pushback in sanctuary states. Haley Sukayama noted that California and Maryland are actively passing electronic health record privacy laws.
To protect the data itself.
Exactly. The goal is to prevent out-of-state doctors or law enforcement from peering into shared medical databases and seeing procedures that were legally performed in those sanctuary states. They were attempting to build legal fortresses around the medical data itself.
But true protection, as the panel stressed, requires cross-movement solidarity.
What does that look like?
It means recognizing that the surveillance tools developed and deployed against immigrant communities and marginalized groups are the exact same tools now being turned toward reproductive health care. It demands sweeping, systemic consumer privacy laws at the federal level, not just individuals playing a losing game of defense on their personal devices.
So, what does this all mean? Let's bring the pieces together. This deep dive into our sources reveals a stark, undeniable reality. The fight over abortion is no longer just a medical debate happening in a clinic or a constitutional argument happening in a courtroom.
Not anymore, no.
It is a massive multi-front clash. It involves the federal postal system colliding with state borders. It involves opaque, flawed algorithmic censorship on platforms like Meta. And it is deeply entangled with the relentless digital surveillance of our daily lives, from our private messages to the license plates on our cars.
The walls of the medical clinic have vanished entirely. The battleground is now everywhere that data flows.
Which leaves you with a final lingering thought to mull over. If state lawmakers eventually succeed in using digital driver's licenses, geolocation data, and search histories to prosecute individuals crossing state lines for healthcare, could the legal precedents established in the fight against abortion ultimately become the exact same legal framework used to dismantle the digital privacy of every single American, regardless of their medical needs?
It's a chilling thought. Once the architecture of mass surveillance is legitimized in the courts for one specific purpose, history shows us it rarely stays confined to just that purpose.
Suddenly, that private doctor's visit behind a closed door feels like a relic of a bygone era. Thank you for joining us on this deep dive. Stay curious, stay informed, and we'll see you next time.
For more episodes related to media, social media, tech, and privacy, visit our YouTube channel, Independent Thinker LLC.